Hi there, I'm Lucy Whitaker. I'm a specialist motoring solicitor. This video is just an overview of driving or being in charge of a vehicle while over the limit. I'll also be touching briefly on being unfit while in charge or over the limit, but nowadays these are far less common offences, partly because they can be more difficult to prove, and to some degree they've been replaced since the introduction of reliable intoxilizers. So let's start with drink driving, as this is the most common of the excess alcohol offences. For an offence of drink driving, the prosecution need to prove two things. The first is that you drove the vehicle on a road or public place, or were attempting to do so, and that you did so after consuming so much alcohol that you were above the prescribed limit. If they didn't have evidence that you drove or attempted to drive the vehicle, but were in charge or in possession of car keys, the police are more likely to consider a charge of being in charge of a vehicle while over the limit, and I'll talk about that briefly a little bit later. If you're convicted of drink driving and there are no special reasons, which are covered in a separate video, the court must disqualify you from driving for a minimum period of 12 months. If you've been convicted of a relevant offence within the 10 years prior to that, then you must be disqualified for a minimum of 3 years. The period of disqualification can be reduced by successfully completing a drink driver rehabilitation course if the court decides to offer that to you. The course reduces the disqualification period by a quarter. There's no way, therefore, of receiving a disqualification of shorter than 9 months after the course, no matter what other people may have told you. And you cannot use exceptional hardship to avoid a ban, because this is a mandatory ban. In drink driving cases, there is a presumption that the level of alcohol in your system at the time you that you gave the police sample is the same as it was at the time you drove. That doesn't mean that you can't raise what is called a hip flask defence if you've consumed alcohol only after driving. And that is what put you over the limit, but the burden will be on you to prove that you were under the limit at the time you drove the vehicle. In alcohol cases, it's typical for the police to administer a roadside breath test, and if that's positive, to arrest you and take you to the police station for an evidential breath test. The roadside breath test cannot be used to prove drink driving. It's merely a way for the police to confirm their suspicion that you are over the limit. They don't need to administer a breath test if it's clear to them that you are intoxicated. They will simply arrest you for being unfit. At this stage, I'll turn briefly to the offences of being unfit. These offences are similar in that the prosecution must prove that you drove or attempted to drive a vehicle on a road or public place, or were in charge of one. However, they don't need to prove you were over the alcohol limit, but they do need to prove that your ability to drive was impaired because of the alcohol. Typically, that evidence can come from witness statements from the police about your demeanour. They will often say that you were slurring your words, unsteady on your feet, etc. As I've said, it's rare for these unfit charges to be taken to trial, because although the police may initially charge you with being unfit, if there's an evidential breath test, it's usually amended to a charge of being over the legal limit. So there's a lot of case law on the reliability of intoxilizer machines and challenges to them. Most machines nowadays are extremely reliable and produce error codes if there's any reason that they're not working correctly. That said, it is possible to challenge them, but it will be necessary to provide a good reason why the device may not be reliable. So by that I mean something that raises some doubt on the reading produced, which then requires the prosecution to prove that that was a reliable reading. It's quite a technical area of law, and it's not something I can go into any detail here, but I am more than happy to advise anyone who's considering challenging an intoxilizer. There are other defences to drink driving where there are specific procedural errors made by the police, and even in cases where clients intend to plead guilty, I always check to see if an error has been made. Again, it's important to note it's only specific fundamental errors that can provide a defence. Finally, just touching on being in charge of a vehicle, this offence occurs when you are in control of a vehicle on a road or public place while over the limit. You don't need to be inside the vehicle for it to be committed. You could be nowhere near the vehicle and still be convicted. However, there is a defence if you can demonstrate that there was no likelihood of you driving while over the limit. For example, if you're at home and after having had a drink you go out to your car to retrieve something from it, the police could consider a charge of you being in charge of the vehicle while over the limit. However, if you can demonstrate that you had no intention of driving because you were just retrieving something from the car, then you should have a defence. The penalties for being drunk in charge are far less severe than if you have been driving or attempting to drive, and at the lower end of the scale you may receive 10 penalty points. Depending on the level of alcohol in your system and your circumstances and previous convictions, if any, you could be disqualified from driving. As always in these cases, there's far too much for me to go into in a short video, so if you'd like more information, please do get in touch with me. I'm conscious that I haven't referred to sort of alcohol testing with blood or urine, but again, these are things I can advise on, but it's not something I can cover in a video. My details are on the screen if you'd like to get in touch. Thank you for watching.